The case before us today is the armed activities on the territory of the Congo, Democratic Republic of the Congo versus Rwanda. The nature of this case's proceedings occurs through the International Court of Justice. The Democratic Republic of Congo brought an application against Rwanda, and Rwanda challenged this jurisdiction through the ICJ. The rule of law, as it applies to this case, is relevant where one party to a treaty excludes dispute settlement obligations under the treaty before becoming a party and fails to take formal acts to bring about withdrawal of the reservation. Thus, the International Court of Justice lacks the jurisdiction based on that treaty with regards to that country. The Democratic Republic of the Congo, DRC, in its application against Rwanda, tried to argue their case on the basis of the jurisdiction of the ICJ with regard to the 9 treaties with dispute settlement clauses that provided for such jurisdiction. Rwanda was not party to 2 of these 9 treaties, and with regard to the other 7, Rwanda excluded dispute settlement obligations. Thus, Rwanda challenged the jurisdiction of the ICJ on the nature of its obligations. The treaties involved were Genocide Convention Article 9, Convention on Racial Discrimination Article 22, Convention on Discrimination Against Women Article 29, World Health Organization Constitution Article 75, UNESCO Convention Article 14, Montreal Convention Article 14, Vienna Convention Article 66, Convention Against Torture, and Convention on Privileges and Immunities of the Specialized Agencies. Rwanda was not party to both the Convention Against Torture and the Convention on Privileges and Immunities of the Specialized Agencies.
The issue at hand here is where one party to a treaty excludes dispute settlement obligations under the treaty before becoming a party, and therefore fails to take formal acts to bring about the withdrawal of this reservation. Does the International Court of Justice lack jurisdiction based on that treaty? The holding and the decision of this case at The Hague on February 3, 2006, by 15 votes to 2, answered yes. When one party to a treaty excludes dispute settlement obligations under the treaty before becoming a party, and then fails to take formal actions to bring about withdrawal of the reservation, the ICJ lacks jurisdiction based on that treaty. So on the one hand, the Democratic Republic of Congo was arguing a multitude of things with respect to the validity of Rwanda's position. The DRC was mainly arguing that Rwanda's reservations were invalid because they were incompatible with the object and purpose of these many conventions. Take, for example, Article 9 of the Genocide Convention. The DRC's contention with this withdrawal is that it is incompatible with the purpose of the convention under international law. The DRC also thought that Rwanda did in fact withdraw their reservation with regards to the Genocide Convention, with a statement on March 17, 2005 by Rwanda's Minister of Justice before the United Nations Commission on Human Rights. The DRC claimed that this statement constituted of having legal effect in regard to withdrawal of their reservation. In its entire application, the DRC made the following requests. Rwanda has violated and is violating the United Nations Charter by violating the human rights which are the goal pursued by the United Nations. Rwanda has violated the International Bill of Human Rights as well as the main instruments protecting human rights by shooting down a Boeing 727 owned by Congo Airlines on October 10, 1998 in Kindu, thereby causing the death of 40 civilians. Rwanda has also violated the United Nations Charter. And finally, by killing, massacring, raping, throat-cutting, and crucifying, Rwanda is guilty of genocide against more than 3,500,000 Congolese, including the victims of the recent massacres in the city of Kisangani, and has violated the sacred right to life under the ICCPR, the Convention on the Prevention and Punishment of the Crime of Genocide, and other relevant international legal instruments.
The DRC wanted all Rwandan armed forces to quit the territory of the DRC so as to enable the Congolese people to enjoy their rights to peace, Rwanda to withdraw their armed forces from the DRC to be entitled to compensation from Rwanda for all acts of looting, destruction, massacre, removal of property and persona, etc. The Republic of Rwanda requested that the court adjudged and declared that it lacks jurisdiction over the claims brought against the Republic of Rwanda by the Republic of the Congo. In the alternative, that the claim brought against the Republic of Rwanda by Democratic Republic of the Congo are inadmissible.
The main principle here is that where a state has apparently not granted consent to the jurisdiction of the ICJ will not advance the case past the preliminary matter of jurisdiction, regardless of whatever atrocities the state has in fact committed by the non-consenting state. Also, as is the case here, the fact that Rwanda showed evidence of non-consent means that reversal of this position would require an overt act by the state in order to convince the court that consent to the jurisdiction of the ICJ was granted. So any acts that Rwanda may have made that go against the treaties brought forth in this case become null due to the fact that the DRC has no merit with the ICJ to go forth.
Furthermore, the court with respect to this case wished to reiterate that there is a fundamental distinction between the acceptance by states of the ICJ's jurisdiction and the conformity of their acts with international law. Regardless of whether or not a state has included dispute settlement obligations under a treaty is irrelevant to the fact that they must fulfill their obligations under the United Nations Charter and any other rule of international law that are relevant.